Well, good morning, everybody, and welcome to today's webinar. I'm really pleased to partner with BBSI and talk to everybody about California wage and hour issues for the non-California HR professional. I'm very delighted to be here. I'm going to run through a host of issues over the next hour. And on our program here today, we certainly have a Q&A box for you to answer or ask any questions. I'll endeavor to get to those during the webinar today. And then ultimately, if you end up having anything that hasn't been addressed, we'll try to go ahead and get that addressed and out to everybody after the webinar. So welcome, and here we go. I'm glad to be here. Sorry we can't do this in person where I actually get to see folks and interact with you all, but we'll do our best to go through and have this information jump off the page for you. My understanding here as a baseline is we're going to be talking about issues that you as HR professionals in different states may have less familiarity with here in California. Obviously, it is a very unique state, mostly because it's extremely litigious. And what we end up seeing is a host of attorneys. I think the phrase that most often comes to mind here in California is you can't swing a dead cat without hitting an attorney. Those of you that are cat lovers, my sympathies and apology for that joke, but certainly it goes to exemplify how many attorneys we have out here. And I wanted to go through why some of the attorneys love the wage and hour litigation out here, and why they go ahead and pursue so much of it when we're here in California. So the judgments in this area have a multiplying effect that really go ahead and have numbers get up very, very quickly. They also have a fairly long statute of limitations, so everything under California Labor Code is 3-year statute of limitations. We're looking at a 4th year under the Unfair Competition Act, and so in those instances, they reach 4 years back from the date a complaint actually gets filed. And then all of the wage and hour violations under their various theories continue to roll forward and add more and more time after the complaint gets filed. So there's a real rush to go ahead and initiate the action, and then they want to pause it and slow it down because it just adds to the potential damages that they're seeking when they go ahead and make these claims. Here in California, there's a couple other issues with wage and hour litigation. One is the potential for liquidated damages for the non-payment of wages that are owed. That immediately doubles a recovery. And so even a plaintiff that is pursuing just a small amount of wages, let's say it's $15,000, under a liquidated damage recovery, they would immediately jump to 30, get that windfall, and then have automatic attorney's fees. That's probably one of the bigger drivers here, is the fact that a plaintiff in a wage and hour case can recover very little, a very small amount. And then all of a sudden, all of the attorney's fees that the other side has claimed, they go ahead and get awarded those. Most courts will be pretty sympathetic to awarding someone, especially in an instance where an employer has gone ahead and contested the claims for the wages. They'll go ahead and award attorney's fees at very aggressive hourly rates, and they will go ahead and pour hours into it, or at least claim that they poured hours into it, and get a very, very large award of attorney's fees. So we need to watch out for those situations. It puts a real premium on responding to demand letters that you might learn of through your California clients right away, so that we can understand what the potential exposure is. We can provide the client some sort of analysis before the lawsuit starts. Maybe that creates an opportunity to go ahead and resolve some small issues before the attorneys pour hours into them and all of a sudden claim that they're going to get those awarded to them, and so we have to pay for every minute that they spent on a case. So no one told me when I was looking to become a lawyer that I was going to have to do so much math, but class actions, PAGA cases with huge penalties end up causing a lot of math. And so I've tried to break it down as simply as I can to explain why people like these so much. And in California, we have a lot of litigation right now going on about 10-minute breaks. So I use that as our math problem today. And let's assume we have one missed 10-minute break with a minimum wage employee right now at $15 an hour. But for the sake of a class action where we're looking back in time over 4 years, we might see an average hourly rate lower than the current minimum wage. And so I've used 12 in this instance. And let's assume we have 25 current employees, 75 past employees over the last 4 years. Just that one 10-minute break ends up totaling $465,000. This is an extraordinary sum for just the 10-minute missed break. That doesn't include penalties that go along with it under PAGA that really explode these numbers into 2 comma cases with multiple millions being claimed over a simple 10-minute amount of time. And it puts a real premium on making sure we have everything perfect when it comes to these wage and hour questions, which is why I'm going to spend all of our time today talking about that. We can certainly go ahead and talk about leaves in another instance, but it's so important right now to talk about wage and hour litigation in California that I thought that's where I would concentrate our time today. PAGA claims have been in the news recently, largely because of a U.S. Supreme Court case called Viking Cruises that dealt with the ability to arbitrate and enforce arbitration agreements, including PAGA. PAGA applies to or means and refers to the Private Attorney General's Act claim. It's a 2004 piece of legislation that came out. And what it does is it allows one employee to be theoretically deputized as an attorney general for the state of California, seeking civil penalties that should be the state's property as a result of wage and hour violations. And what happens is the individual goes ahead and gets an award under PAGA. 75% of those penalties end up going to the state. They go to the LWDA. That means Labor Workforce Development Agency. And so you might see this reference here spelled out. That is Labor Workforce Development Agency with the state. The 75% of those penalties ends up going to the general fund for the state of California. And then 25% ends up going ahead and getting distributed to your past and present employees. And then, of course, the ever-present attorney's fee shifting also applies to PAGA cases. And so everybody wonders, well, why are PAGA claims so expensive? There are a situation where they look back 1 year from the date of the LWDA letter, when they go ahead and initially put the state on notice of this potential claim. And every pay period goes ahead and causes a new penalty per employee. Well, that in and of itself is a big number, but not the gigantic numbers we're hearing in settlement discussions of PAGA cases. But what the plaintiff's counsel does is they go ahead and use a process called stacking in these cases. And what happens is they end up going ahead and taking all of the common claims that they might go ahead and otherwise make. A pay stub violation, a meal period violation, a rest period, failure to pay at time of termination that causes normally Labor Code 203 penalties. Can also cause PAGA penalties. And all of these different things end up causing them to what they do is stack, so that every single one of these go ahead and causes a new penalty per pay period per person. Well, what happens is if they have the typical situation where they might have 5 of these, then every pay period is getting stacked penalties of 200 times the number of violations, meaning 5, per person. And that's how these end up getting to be out of control potential recoveries by the plaintiff's counsel that they go ahead and hang over everybody's head. And with that, they end up going ahead and getting very large settlements. Typically, there is a gross settlement amount that will get negotiated. A third of that comes off the top and goes to the attorneys. And then the split of penalties between state and employees ends up being made after that. The estimated number of, there was a recent study that was done, and we submitted it on behalf of the Viking Cruises case in an amicus brief. And what ended up happening is we took a look at the number of times that an LWDA letter on average has been submitted to the state for PAGA claims since the law's inception in 2004. And what we found is that every workday had an average of 14 PAGA letters that have been filed in the state of California. Now, that's certainly ramped up over the last, let's say, 5 to 8 years. The pace has been even more brisk than 14. But to have an average since 2004 of 14 of these letters being filed every day is just ghastly. Well, the next question is, how many times has the state actually sued and not left it to the private attorneys to go ahead and prosecute one of these cases? Because after all, the state can go ahead and say, oh, we got your PAGA letter. Thank you for submitting that to the LWDA. We're going to pursue this case. We think it has enough merit. Well, they've done that exactly 17 times since 2004. All of those other PAGA letters at the clip of 14 on average per day have gone out to the plaintiff's attorneys. The plaintiff's attorneys have sought huge amounts of money. They've gotten certain amounts of settlements, and then they take their cut for that, and they make an enormous amount of money doing this. And the most common areas that they sue on are the 4 I have up here. You'll see meal break claims, rest break claims, overtime, and pay stub violations. And I'm going to go over each one of those areas because at the very least in a webinar like this, these inform us about what areas we have to concentrate on most, because these are the areas that everybody is looking at when we go ahead and start to look at this. I put in the materials, and I'm not just going to go ahead and read slides today. That's not my role. That's not my gig. But I'm going to go ahead, and this is made available to you so you can download it, you can read it. It'll put you to sleep at night if you're having trouble with that. You can go ahead and just pull this out, read it yourself, and you'll be out like that. But I did put information that talks about what a PAGA letter is, PAGA notice requirements that might be out there, so that when you have a client that's calling you and say, hey, I just got this, you'll have some information to draw upon, and you'll have some idea of the structure. The basic structure is that in the end, the plaintiff's attorney or the plaintiff themselves has to file this letter with the LWDA. It's supposed to identify what the claims are. It doesn't include a whole lot of facts. The employer can respond and file a response. And then after 60 days of sitting there, then the plaintiff can go ahead and initiate the actual PAGA lawsuit. There's also a period of time, though, during this where the employer has an opportunity to engage in a safe harbor provision. And if there's certain claims there, for instance, if it is only a claim about pay stubs, that something is wrong with the pay stubs, then there's an opportunity for your client within 33 days to cure that violation. Oftentimes, this goes ahead and comes up in the instance where the wrong name of the employer is used, and someone went ahead and used their DBA, and someone is alleging that that's improper. Even though there's a case out there that says using a registered DBA is perfectly fine, someone may want to go ahead and take advantage of the safe harbor, put their actual company name on there, and cure it. But what they would have to do is they would have to resend everybody every pay stub for the year prior to the LWDA notice. That's a big ask. So it's something that you would have to jump on pretty quickly. There are not abilities to engage in a safe harbor provision for things like meal and rest periods or overtime claims, and oftentimes we're disputing those anyway, and so it becomes a real problem if we go ahead and try to use a cure provision for that. But some of the hyper-technical ones, like a pay stub, that's a good avenue, and it's something we should be aware of because clients may want to go ahead and take advantage of that. Biggest thing to do if you get one of these LWDA letters, you're going to want to engage or tell the client to engage with whoever their counsel is. We want to make sure that we can get eyes on this and not miss an opportunity if there is one, or at least talk about the strategy and the early strategy when a notice goes ahead and comes on board. We've talked about the notice a little bit. There are supposed to be there is supposed to be a challenge available for notice not being sufficient. We typically do not see these at this stage, whether that is a function of the defense bar's approach to this. Generally, the notice is not challenged at the LWDA letter, and those are typically prepared for and then litigated in court once the complaint actually gets filed. Now, for your clients faced with these difficult situations, the other issue that comes up and questions you might be asked is, well, how do we solve this problem? And just like many of these problems, there are a couple solutions. One is obviously you can go all the way to trial, you can get your day in court, and you can go ahead and see how that turns out. The other option generally is a settlement. And most people do take that. For all of those PAGA cases, by the way, there's one trial out there that we can pull upon to see how that actually went. There's a couple people that have won some motions on some technical issues during the litigation, but generally these cases do settle. It's important for the client to know that these settlements are generally public. They have to go through a court approval process, and they are very technical. They have to identify the provisions that are being settled, what the PAGA period is, who's part of the PAGA period. All of those employees are going to get notices like a class action. All of those things are going to be reviewed by a court and judged about whether it's reasonable in relation to the claims made and the defenses being made. And so clients will need to know that these PAGA settlements are subject to court approval, and they're not something you're able to just hide away, settle without anyone seeing them. There's notices and all sorts of things that go along with this. So why do these continue to be such a problem? Well, they're certainly broad in the ways that the employers can get sued. They're exponentially more expensive than a labor commissioner complaint that one of your employers, your clients may go ahead and be faced with by an employee. They are much, much more expensive to go ahead and litigate against and to go ahead and try to resolve. They've increased the potential liability where it's fairly routine to hear initial demands in this case from opposing counsel of 20, 40, and in some cases $90 million, depending on the size of the employer. I had a modest size employer recently, and the demand was $99 million on one of these cases. It seems ridiculous. It certainly is. It didn't get much of a response in my case, but there is a pathway, is the problem, with PAGA to those types of ridiculous numbers. And so we need to go ahead and see if there are options that we should be talking about with our clients about arbitration. And so arbitration in California is permitted. There's certain restraints to that. You can go ahead and waive class actions. Right now, Viking Cruises has also allowed employers to enforce arbitration agreements that waive representative claims. And the argument under Viking Cruises is that in the end, an individual PAGA claim by a person can go ahead and be compelled to arbitration. And if there's no one left in the representative portion of that PAGA claim that has the remaining claims, then those have to be dismissed. That was the rationale of Viking Cruises. There are currently some plaintiffs' attorneys that are, doing a serviceable job of trying to argue against that and having the representative claim stayed in court so that they can hopefully wait in their mind for the legislature to go ahead and solve this problem by saying that a person does not have to even have their own claim in order to represent other employees in a PAGA case. And there's all sorts of discussions going on right now at the legislature, which is right over my shoulder here, out the window. And they're going to go ahead and talk about whether they solve that problem for the plaintiffs' bar. But right now, we really should be talking to people about whether they want a mandatory arbitration provision that would waive class action status for an employee, send them to arbitration. They do have to pay the cost of the arbitration, which is not inexpensive. That can be on a single person, $30,000, $50,000 for the arbitrator to hear the case. But it's a fair trade when we're looking at avoiding a class action or a PAGA case in court if we can go ahead and do that. And many, many people are looking at the option of arbitration. If that's something you want to talk about more in relation to specific clients, I'm happy to chat with you about it. There are certain provisions that have to be in the agreement in order to be enforceable. So we should definitely talk about it before they get implemented. A lot of times these issues are still popular because there's a lot of employers that keep missing certain things that are their obligation in the labor code. For instance, there is typically some violation rate in meal period claims. Generally, there are very few employers that are 100% compliant on meal periods. The 100% compliant meal period program typically is one where the employer goes ahead and tracks everybody's time, including their meal periods. And if a meal period ends up being late, not taken, or short, they go ahead and automatically pay the premium at the time the meal period is missed in that pay period. The rest periods are another very popular claim, and recently there's been a rash of what's known as third rest break periods, where people are working longer shifts and are entitled to a third rest break, but everybody thinks, oh, well, they've already gotten their 2 10-minute breaks. That should be fine. We're missing some stuff still, and we're going to talk about it and identify how to guard against that. Why are they so expensive to defend? I mean, for the most part, the reason that they're so expensive to defend is we're analyzing huge amounts of data of current and former employees in order to calculate the potential penalties, and also go ahead and make some different assumptions based on some facts and extrapolate out how that would move the numbers down. But I've put another overtime claim example here in order to demonstrate why we're going ahead and spending so much time drilling down on this. So if you have 50 current supervisors and 5 former supervisors who worked for an employee during the last year, the statute of limitations for a PAGA case, and they're all alleging they were misclassified and therefore denied overtime. Well, the overtime statute provides a penalty for unpaid overtime, first violation of 50 per employee per pay period, and 100 for the subsequent violations. Under the PAGA penalties, you can see the extrapolation that for one person, we're looking at a modest sum. We're looking at $27.50, not bad. Then we get into the penalties for everybody else at $100, and we immediately jump up to $137. And then we go ahead and have additional, when those get added together, you end up with a total of $140,250. And that's plus then attorney's fees and costs on top of that. The numbers here for just 55 employees get very big for that one violation. And then they claim that as a result of the misclassification, they missed meal periods. That would be another roughly 140. I think the penalty statute's actually larger. It's about double of that, so you'd be looking at 280. And then they claim rest period violation, and they would have another 280. And that's how you very quickly, even for 55 employees, approach $1 million. So we need to make sure that we're paying attention to this and we're understanding the most common claims. And so I'm going to start with a discussion of the Brinker case. This has to do with meal periods. And it sounds really great. So we're going to start with something that's super positive for employers, or at least it sounds very positive. And then I'm going to dash your hopes on the rocks of the shoreline here, making you think about how we're going to go ahead and comply. So Brinker was a California Supreme Court case. It involved a restaurant group, Brinker Restaurant Group, and it stood for the proposition that an employer only has to make meal breaks available. They don't have to ensure that they're taken, but that an employee, because it talks about an employee being relieved of all duty by their employer, that the employee can go ahead and choose to take the meal period or to not take the meal period every single shift that they work, that we don't have to police the workforce as an employer. And it sounded really great. Well, in practice, what ends up happening is the employee, without going ahead and recording a meal period, ends up saying that, look, they were denied or it was suggested by a manager that they go ahead and not take that, that the press of business ended up interfering with their ability to take it. And that was a real problem. And that has continued to be a real problem. Because in the end, if there's no record of the meal period, we open ourselves up to an employee making things up. And that's a real issue here. It certainly highlighted the need for meal periods, but the cases that have come after it have suggested something pretty stark that I wanted to go ahead and mention to everybody. There was a case that came out about a year ago, and it talks about whose burden it is under certain circumstances to demonstrate things. If there is a record of a meal period that is compliant, meaning someone has had checked out for a meal period before the end of the 5th hour of work and it lasted 30 minutes or more, then it would be the employee's burden to demonstrate each and every instance where they allege that doesn't reflect that they actually got a meal period. They ended up working off the clock, they clocked out and continued to work. The burden would be theirs to demonstrate that that is not a compliant lunch. That same court ended up going ahead and saying, in the instance that there is not a properly recorded meal period, meaning it's late, it's not recorded, or it's short, in any of those instances, it is the employer's burden to show in each and every instance that a compliant meal period was provided for under this Brinker analysis. And that's a real tall order. If the employee is saying, you know, my manager 2 years ago suggested that I clock out and continue to work, or that I delay my lunch until the 6th hour. And so I went ahead and did that. We had a lunch rush. I couldn't go ahead and step away. All of those instances where it's our burden, where we don't have a compliant meal period, that is going to be an enormously hard task to demonstrate each and every day that a non-compliant meal period shows up, that one was available. By doing that, if I'm going to read that case and the Brinker case together, the smart thing for someone advising California employers and for the California employer themselves is to make sure and insist that an employee take every meal period in a compliant manner of at least 30 minutes where they're clocking out before the end of the 5th hour. And on a time clock, that's going to show up with a 4 in front of it. It's going to be at 4 hours, 4 hours and 30 minutes, 4 hours and 59 minutes on the time clock, so that we don't start with a 5. We need to make sure that we're going ahead and doing that so that we don't have the burden of showing that one was provided, because that burden is a really, really tough one for us to go ahead and do. And so post-Brinker really ends up going ahead and being undermined by this burden shifting that the courts came out with last year. We need to make sure that we're compliant. So here's the basic rule. Before the end of the fifth hour, at least 30 minutes. It's uninterrupted. They can leave the premises. They have to be free to do that. It should be in the policy that they're free to do it. And that's because there's a case out there that suggests if you don't have that language in there, that the employee would have to stay on the premises and they're not being relieved of all duty. Therefore, that's an on-duty meal period that you would have to pay for. So we want to make sure that we have compliant policies that talk about each one of these things, that people are going ahead and actually taking them. And then they can go out and, sit in their car and, go on Instagram, watch a TV program, whatever they do on their 30 minutes or 45-minute time period. I do try to encourage employers to look at things a certain way, that they shouldn't be that concerned about making sure that employees are back right at 30 minutes on these. It tends to create a situation where we have a lot of short meal periods that show up in the time cards, and employees are off the clock during this time. And so all it does is elongate the employee's day. If you have a 45-minute meal period, it doesn't increase the person's labor cost. All it does is make the end of the person's day 15 minutes later than it otherwise would. What it does for the employer is it avoids a bunch of people that clock in at the 29-minute mark that technically show up as non-compliant, and then all of a sudden we have the requirement or the burden to demonstrate that they could have taken 30 minutes, but they somehow didn't. All of those things are vitally important for us to go ahead and be able to demonstrate. Smart employer wants to go ahead and make sure their meal period does not require the employer, that the employer ensures it is taken, but we want a compliant meal period policy. We don't want to impede it, and we want to go ahead and make sure everybody is clocking in and out. There's another option too, where we do like employees, if you use an electronic system, to be able to attest at the end that they were provided all of their meal and rest periods during the day. Those attestations become really important when we're litigating these cases later. And they can waive if they have short shifts where they're scheduled for less than 6 hours. They can waive those with a waiver at the beginning of their employment that waives the ability to go ahead and have to take a lunch if their shift is scheduled for less than 6, ends before the end of the 6th hour. That's a powerful thing to do. Now, I've got a question here. Caitlin, I see your question that you have a client operating in Utah, and employees are sent to California for work in solar installation. When they're working in California for short stints and they live in Utah, they're paying a piece rate, which I'm not sure is the best practice for them. What is the risk tolerance here, and what would be the best way to advise them on pay practices? So there's a lot packed into that, with piece rate workers mainly as the issue. But short-term employees that are working a shift in California, when they are working here, they have to be paid according to California Labor Code law. That means that they are all of a sudden getting 10-minute rest breaks. They are getting their statutory 30-minute meal period, and that has to happen in a piece rate situation. The added level of difficulty with piece rate is that in California, people on a piece rate have to be paid an hourly wage for their non-productive time. Now, rest breaks are paid in California. And so a piece rate worker needs to go ahead and actually track people's rest breaks so that they can pay the proper non-productive time. any time in tailgate meetings, preparatory time that isn't related to the piece itself would have to be tracked on an hourly basis, and they would have to be paid their proper rate of pay for that period of time as non-productive time. Piece rate gets very, very complicated. We should definitely review that client's practices here because it's very different than Utah. They're looking at tracking all of that non-productive time and complying with the meal and rest periods here. There's another great question here, and we have, can you clarify what scheduled for less than 6 hours means? Let me take that first. This is where a person has a schedule throughout the day or throughout the week, and they are scheduled for 6 hours or less. And so you have an employee in lots of industries, maybe a restaurant industry, maybe a retail industry, where they're scheduled for 4, 5, or 6 hours. And then they go ahead and work that schedule so that they don't stray past the 6 hour. In that instance, you could have a written waiver that waives their entitlement to a meal period, even though they work more than 5 hours. So is that for part-time only, or is it applicable to full-time employees who are scheduled to work full 8 hours but were sent home early? It's only those that are scheduled for up to 6 hours, no more, and actually work it. So it would not be full-time employees that are scheduled for 8, but somehow go ahead and are left, sent home early for whatever reason. In those instances, if the person is sent home after the 5th hour of work and there was no meal period, that would be a penalty that would be accrued, and that would be at their hourly rate, whatever it is. So they can waive this meal period. It does have to be in writing. It's only for those that are regularly scheduled less than 6. It has to be revocable at any time by the employee. I will tell you, in practice, most employees never revoke it. They gladly sign these if this is an employer that does schedule people for 6-hour shifts or less. They go ahead and do not want to be there any longer than they have to. A part-time employee like that may have school, may have a second job, and in those instances, they're looking to get out of there as quickly as possible and be paid for every minute that they're going to be there, not stop for a half hour and end up going ahead and move on. One question here from Robin is that, is the waiver per instance, or can it be on file? And it can be on file. There are some creative plaintiffs' attorneys that will argue it has to be each time, and that's not accurate. The DIR, the Department of Industrial Relations, looks at it and says, look, if they have one on file that they signed at the beginning of employment, unless it's revocable, unless it's revoked, it's in place. And so in order to give effect to the idea that a meal period waiver has to be revocable at any time, it would stand to reason that you can have one time, and until it's revoked, it's in place. And then if it's revoked at any time, it would have to be reinstituted, but you could go back in the file for another period of time until it's revoked again. Now, you can also waive a second meal period. In California, for longer shifts, let's say the solar installers are working more than 10 hours a day installing the solar after they come out from Utah, they would be entitled to a second meal period if they're working longer than 10 hours. And that second meal period would have to begin before the end of the 10th hour of work. So 9 hours and 59 minutes on the time clock. Employees can waive a second meal period under certain circumstances, and most gladly do if these circumstances are met. There again has to be a valid agreement. They have to have taken a complete and compliant first meal period, and that is always a difficult standard to meet. And they have to work no longer than 12 hours. So you can have a valid waiver so long as the work is going to end before the end of the 12th hour, and if they've had a compliant first meal period. And so it's very important that the supervisors on the ground understand this so that they're not blowing through the second meal period, relying on the waiver, and then they stray into that 12th hour. And so on the time clock, it says 12:01. That would be a disaster. That would go ahead and invalidate immediately the second meal period waiver. In addition, if they've missed the first meal period somehow, it was short, it was late, it was non-existent, then a second meal period waiver that would be on file and would be otherwise valid unless revoked by the employee, that will not apply to a shift if it wasn't a compliant first meal period or the shift lasted longer than 12 hours. Important for everybody, all of the managers, to know that so that they can plan accordingly. Now, rest breaks, it's a 10-minute net rest break. That is for every 4 hours or major fraction thereof. And it has to be taken so far as practicable in the middle of each 4-hour work period. Generally, what we're looking at, major fraction thereof, has been defined as longer than 2 hours. And so if there is a portion of a workday that lasts longer than 2 hours, there should be a 10-minute rest break somewhere in there that's afforded to the employee. These are paid. They are generally not tracked other than in piece rate environments, and there's no requirement that they be tracked. But we end up having to go ahead and keep track of whether or not people might be signing attestations and making sure that they comply with this issue. There's another question here. Can a meal period be paid for the first and second missed meal break? Yes. I mean, an employee, if they miss the first one and the second one, there would be 2 premium hours that day that would be owed to the employee, if I'm understanding this correctly. I've put a chart here for everybody that takes everybody through the timing of these different rest periods and meal periods. Important to understand that depending on the length of the day, there could be many more than 2 rest breaks that are owed. Again, the rest periods, we do have the same similar definition that they're authorized and permitted. And there is no waiver allowed in these instances, however. They have to be provided, and they can't go ahead and waive this. It does not have to be fully off duty. However, there is a case called Augustus that does and has been interpreted as not allowing an employer to tell employees that they have to remain at the work site during rest breaks. Now, that sounds ridiculous in a lot of instances, where in a 10-minute break, I'm visualizing an employee sprinting down the street, trying to get somewhere in order to buy a Starbucks or whatever, and then racing back. But what's important is that our policy, and this is the homework for everybody, that the policy does not say employees have to remain at the work site during rest breaks. It should not say that. That should be deleted from the policies. Employees should be free to go ahead and try to leave if they want, so long as they get back by the end of the net 10 minutes and not be prevented from doing so. In Augustus, these were security guards that were had to keep their walkie-talkies on them when they went ahead and took a break. The court talked about this situation of not being permitted to leave a work site. But when they really analyzed this case, they said, look, just having the walkie-talkie, even if it doesn't go off, is an uninterrupted meal period. They are not relieved of all duty. They would have to respond to this walkie-talkie if it goes off. And so they awarded a premium hour for every shift that a security guard had in the state of California, and it ended up totaling $195 million in the verdict for a bunch of 10-minute rest breaks. Seems crazy. But we absolutely need to go ahead and make sure that we watch out and don't stumble into this issue. All right, I have some more slides on this for you. I want to make sure that we go ahead and get to a couple other items before we run out of time here. And so I want to talk about some other types of issues other than your meal and rest. So in overtime in California is not a just a 40-hour work week. We have an 8-hour in a day overtime requirement. So hours after 8 have to be paid at an overtime rate of 1.5 times the regular rate of pay. The overtime rate also applies in instances where there's more than 40 regular hours recorded in a week. And then the first 8 hours on the 7th consecutive day in a work week has to be paid at the overtime 1.5 rate. And ultimately, if you go beyond 8 hours in that 7th consecutive day in a work week, you are looking at double time in those instances. Switching real back, are there exceptions to meal and rest break premiums or minimum wage premium requirements in California for for-profit summer camps with camps counselors that we're aware of? No, there's not. There are different exemptions that apply to commissioned employees, to exempt employees, but not to specific nonprofits or for-profit summer camps. Those instances are where meal and rest periods still do apply. There is a narrow exception on on-duty meal periods. I'm happy to talk about that specific instance, but it's a very narrow application of it. And so I don't want to take up our time today. I'm happy, Caitlin, if you want to reach out to me through email to go ahead and deal with that specific question, and then you can pass it along internally to anyone else that might apply to. There's double time, switching back to pay rates. There's double time where over 12 hours have to be paid double, and over 8 hours on that 7th consecutive day. That's a real issue out here, and we want to make sure that we go ahead and cover that. Now, one of the issues here someone's asking about is to address OT exceptions for trucking companies who are performing interstate hauling. So there are exceptions that apply to those that are engaged in interstate commerce and are traveling interstate, meaning they're going between states and not just driving intrastate. If they're subject to the federal motor carrier regulations and they're traveling interstate, then they are subject to the hours of service requirements under the federal motor carrier regulations and not California's overtime requirements. I do want to mention, however, that the courts have interpreted meal and rest periods differently and have said that meal and rest periods, even though they impact the hours of service that a driver might be engaged in, still apply to interstate hauling companies, and that the meal and rest periods would have to still be complied with. We absolutely need to go ahead and make sure that we're going ahead and making meal periods and rest periods available, even though that's going to impact the total hours of service we're supposed to get to people or from people that are engaged in that interstate driving. Unauthorized meal periods should be treated as a disciplinary issue. We still have to pay for the time, but if someone comes to us and says they were performing work off the clock, we should be able to refer back to a policy saying that we forbid that. And an employer technically does not owe it if they didn't know about it or if they did not reasonably know about it. But it is a subject of a lot of litigation, and so I want to make sure that everybody understands you still have to pay for unauthorized overtime, but not off the clock work necessarily. And then the unauthorized overtime you would treat as a disciplinary issue. You would go ahead and warn the person, write them up, and or fire them if it continues. Now, there's a question here I'm noticing on rounding, and rounding applies to both unpaid wages. Rounding applies to overtime or potentially impacts overtime, and rounding also goes ahead and impacts meal and rest. There was a case last year, the same one, that put the burden for non-compliant meal periods that show up in the records on the employer, that said you cannot under any circumstances round meal periods. that meal periods or rest periods, even for piece rate workers, cannot be rounded, and you have to pay true time. So the employee cannot lose time in those instances. I will share with everybody that in the instance of rounding the beginning and the end of shifts, you can go ahead and do that. There is a case call that involves See's Candy that allows for neutral rounding of no more than 6 minutes. And as long as over time, the rounding policy inures to the benefit of the employee. I will share with you that the litigation is all over that last phrase I just talked about. The last phrase of over time, it has to inure to the benefit of the employee, has us in rounding cases, literally going employee by employee and counting the number of times the employee benefited from the rounding and how many times they lost time from the rounding policy. And ultimately, I am finding that most of the time, it is going ahead and having the employee lose time under a rounding policy. We tend to see more instances where an employee loses time rather than gains. I try to share with employers, and I'll pass this along to share with your clients, that unfortunately the reality of a rounding policy is that generally you are taking time away from your best employees and you are giving time away to the lazy, no good, rotten employees that you have. And in those instances, it seems mighty unfair. Your best employees are showing up on time. They might even be showing up a few minutes early, and then that time is being taken away from them. And hopefully you have more good employees than bad employees. And then the bad employees that stroll in a little bit late or always trying to cut the time, they're having their time rolled back where they're gaining time. And you're paying your worst employees more than you otherwise should. So I'm a huge advocate of paying true time at this point. The systems that are out there should allow for that to be done a lot easier than it used to be. And it's certainly more fair to a lot of the good employees that an employer has. And it avoids the potential litigation where we're literally counting to see how many times there was a win versus a loss for the employee, and that we're going to go ahead and fight over. Misclassification of an employee is, I would say, not a real popular claim out here other than in the independent contractor gig economy space. But we need to make sure that everybody understands for their customer or for their clients that just paying someone a salary and the minimum required salary of double the minimum wage isn't enough in California. They have to meet a duties test, and the duties test, for the most part, it is a real quantitative analysis. So the salary test is pretty easy. 2 times the state minimum wage. It keeps going up and up and up. So every time the minimum wage goes up, we go ahead and have to see an increase in the salary. The duties test is a primarily engaged quantitative analysis of, are they spending more than 50% of their time engaged in the exempt activities? And for some employees who certainly like a salary, it is very, very difficult to comply with that aspect of this, to go ahead and see that each and every duty that they are involved in, especially the good employees that jump in and help employees and do stuff. In the end, that's a very difficult scenario to go ahead and on a quantitative basis end up going ahead and justifying. So we want all of your clients to understand that. We want all of the clients to understand that that over time it is going to take some adherence to the job description and making sure that people are actually doing the job they're supposed to, rather than pitching in so much to help other people who are failing at their job that they destroy the exemption that we think the position should deserve. Now, wage statements in California, we have a bunch of things that have to be on there. I've listed them for you. We need to make sure that all of those are on there. That's the employer's name, the address, the last 4 digits, etc. If those items aren't on there, the penalties under Labor Code 226 will start to kick in. And those can end up being a maximum of $4,000 per person. That ends up adding up over time in a class action. But the real risk here is PAGA, because while the cap of $4,000 might apply in the instance of a straight Labor Code 226 claim, under PAGA they would get, for each payroll that's run, another penalty per employee that doesn't have a cap to it. It can certainly, over the course of a year, or if it continues into litigation over several years, end up going ahead and being more than the straight 226 claim. And so how much, a lot of people ask, how much could one of these claims cost? I've done some analysis for you, again, for the idea of a 100 employee group, so 25 current and 75 former employees, with an aggregate penalty of $4,000 per employee. And in there, if you get one of these wrong, it's $400,000. And you'll never see a settlement below that. Plaintiffs' attorneys will feel that that is an absolute minimum. And if you get one of the things, one of the items not on there, they believe that that is an absolute floor for negotiations. Now, it may not be a floor for negotiations if we're looking at a derivative wage statement claim. And what I mean by that is someone says, look, you didn't go ahead and provide rest breaks, and therefore certain premium hours that should be on the payroll or the paycheck are not reflected on there. What they have to do in those instances is show they went ahead and proved the rest break claim, and therefore they get the 226 penalty. Those derivative claims are not going to be viewed in the same way as a straight 226 claim where one of these items isn't there. If one of those items isn't there, then you're looking at a pretty big liability very, very quickly. Very hard problem to solve for less than the baseline $400,000 here. So we want to make sure that payroll is done correctly. We want to make sure that your employers know how to do that. Make sure we're verifying the information if we're running payroll for them, making sure we're verifying that all that information is available to us and that we're getting it right on the pay stubs. You can go ahead and pull pay stubs. You can check against that slide, make sure the information is there. And if it's not, you can correct it very quickly in order to at least cut off the potential for someone to come back and make that claim. Now, in California, we also have payroll personnel records that people can go ahead and ask for. There are penalties if they're not complied with. This is oftentimes the first time your client may learn of a potential lawsuit. These are generally from plaintiffs' attorneys, and they have 30 days to provide a copy or access to the personnel file. Generally, most people are not wanting the attorney to come into their workplace, and so they are producing these to them. And lots of times we're doing it on their behalf. So the plaintiff's attorney knows we're here. You're going to go ahead and make some sort of demand. We're going to defend against it and not just let you get away with this. You'll want to make sure that everybody understands that the personnel records, 30 days, it can be the person or their representative. They can also, under the Labor Code, request their personnel records under Labor Code 226. And an employer has 21 days, payroll records. And the employer has 21 days to get the payroll records to the other side. So a shorter amount of time, same penalty, $750, and then they can get attorney's fees if they have to try to enforce to go ahead and get that. There's a question here about sick and vacation time on wage statements. You know, if sick pay, under paid sick leave for California, does have to be under the pay stub or on the pay stub, it is not part of 226. It comes through a different labor code, but it does have to be on the pay stub. Vacation should be tracked there, but doesn't cause a penalty unless someone has a PTO program where sick and vacation are combined. But there is a pay stub requirement that your paid sick leave does have to be on. If someone makes a personnel records or payroll records request, make sure that you're responding timely. We don't want to have some small little giveaway type claim that's available to a plaintiff or a plaintiff's attorney that's about to sue. We want to make sure that we respond to those in a timely way and that they get those. And then we're getting a heads up for the battle to come. We're getting ready for that. Self-help remedies, I've got some information there. I'm going to move through this so that we can make sure that we cover everything. There are only certain deductions that are allowed, and I've spelled it out for everybody. It's hardly any. And we need to make sure that employees go ahead, or employers go ahead and know that they can't end up going ahead and deducting for many things. We're looking for empowered to do so by the state or federal law. That's taxes, SSI, disability payments, that type of thing. A deduction when it's expressly authorized in writing by the employee to cover insurance premiums, hospital or medical dues, or other deductions that not amounting to a rebate or deduction from the standing wage. This does not include someone that has loaned an employee money and they are getting a repayment of that. That is a common misperception, and those deductions from wages shouldn't be made. The wage check should go to the employee, and then the payment from the employee to repay a loan should be made separately to the employer so that we don't risk a Labor Code 224 instance. We need to make sure that we go ahead and do that. So there are only limited circumstances where other types of deductions might be allowed. You've got to be able to prove a dishonest act, like they stole something, or that there was a willful act where they destroyed a computer equipment, for instance, where you've got them on a video because you were recording the webinar and they take a bat and they smash the computer and you can go ahead and see the recording. It would take that type of situation in order to allow deductions for damage or dishonest acts that they engaged in. Make sure we're being careful of that. There was a question here from Robin, is there a time frame for time cards when requested? I think I already covered that, but just to make sure we cover it, it's 21 days. And we need to make sure that employers know that third parties, meaning the plaintiff's attorneys, can also request it. It's not just the individual employee themselves. Arbitration agreements are something, again, that I am encouraging everybody to take a look at in California. We want to make sure people understand that that's an available situation to them. It does come with costs, but in order to avoid the crushing impact of a class action or PAGA cases, in those instances where employers might have permanent employees here of a certain size, I would probably put them at about 50 employees. We're going to make sure that we go ahead and watch out for instances where someone can bring a class case or an unchecked PAGA case. For those that are bringing employees in for a very short amount of time, that's a situation where that's going to be a judgment call for people. If you have a small amount of employees, we're generally not seeing that. There's a question here about loan repayment being part of a payroll deduction. Is it illegal or not recommended? I put it in the certainly the not recommended, and could someday be determined to be illegal. And the reason I say that is that it's not specifically provided for in the Labor Code 224. Many people believe that you can do it. I think employers would be shocked to learn that they can't if they've loaned someone money like that. We do know that any prior written authorizations for deductions, even for health care or that type of thing, immediately cease at the time of a separation or termination. That includes an authorization for a bank deposit for their payroll check, so that the final paycheck would have to be done or with an actual check instead of a direct deposit. Those authorizations immediately cancel upon someone's separation. But for the loan payment, since the language isn't specifically provided for, There's an open question about whether it would be determined at some point to be illegal. The way our courts have gone recently, they take a pretty strict view of things that would be detrimental to an employee, that if it's not specifically provided for, it's not permitted. And so I would definitely not recommend it. I fear that a court will eventually determine that someone has done that illegally. Last topic before we just go ahead and end for today is not having to do with our latest insights, but having to do with expenses. Expenses have become a big issue. We have Labor Code 2802 down here. Expenses have to do with people that are permitted knowingly to use a cell phone as part of their work, where they've got email on their cell phone. They are getting notices on their cell phone. They're available that way. There is a lot of claims that you have to pay for the reasonable usage of the cell phone plan for the employee for business usage. It comes under a certain case that found just that. And so we need to make sure that our employees understand that if we either narrow the amount of people that can have access outside of the workday at home through their cell phone devices, or that we are paying some sort of monthly stipend for that access. Most people are paying $50 a month as a expense reimbursement to employees for their cell phone plans. I've seen some people stray into $25, $35 a month. But if you are going ahead and having employees on their personal cell phones, you do have to pay for the reasonable use for work of that cost. That comes up in several other instances. Obviously, with people working out of the house, there are claims that are starting to pop up, certainly about the home internet and the connectivity, or if they are not using company equipment, the actual cost of the equipment that they are using for work would have to be paid for under 2802. And so employers should carefully go ahead and approach this idea of remote work, because you need to think about, okay, what are we going to reimburse on a monthly long-term basis for that at-home employee? There are some plaintiffs' attorneys that are flirting with the idea that other things in and around someone's home that are being used for business would have to be reimbursed, like a reasonable percentage of heating and air. Some are suggesting that a reasonable portion of someone's rent or mortgage would have to be paid for by an employer under the same analysis that the cell phones would have to be used and paid for. We know that someone's using a certain segment of their home for work. They also have personal use in and around the home. But just like a lease cost in an office building, there's a cost to the employee for that space, and there's a reasonable percentage of it that's being used for work. There's a very attractive argument there. No one has pushed it. We don't have an opinion on that. I just know from talking with plaintiffs' attorneys, it's on their mind. And when they're talking about it, they're eventually probably going to sue over it after enough time goes by. And our clients should at least be aware that they need to be thinking of it. I haven't advised anybody to start paying anybody's rent or anybody's home office percentage of their mortgage, that they're probably writing off now against their income tax anyway. But I think those issues are going to come, and we're going to be faced with them. Right now, the most prevalent one is the cell phone reimbursement, and then home internet if someone is working at home and they're having to connect. The reasonable portion of those, there should be some reimbursement for that. So I really appreciate everybody coming today. I know that there seems like with California, just tons of other issues that we would want to address that are unique to our, I'll call it an environment. What I would encourage anybody that has questions to do is to go ahead and email me those questions. You can obviously go ahead and call me too. I'm an employment law geek, so I love to deal and tackle with the issues that you might be specifically faced with. And I know that it's a huge challenge for those that have clients that are based in other states, but they have a couple employees out here in California that they haven't moved out yet. There's still a few of those companies. And until they do, when those questions come up, please feel free to use me as a resource. I'm happy to go ahead and address those questions. So thank you, everybody. I really appreciate it, and enjoy the rest of the day today. Thank you very much.